When a family has to deal with a legal issue, going to court can feel, well, like a battlefield. It's draining. But what if there was another way? In the Philippines, there actually is a system set up to be less of a fight and more of a structured conversation. So we're going to dive into what's called court-annexed family mediation and see how it really offers a better way forward. I mean, if you've ever been close to a situation like this, you know exactly what I'm talking about. The emotional weight of it all is just immense. There's the stress, the not knowing what's going to happen, and of course, the money. It can honestly feel like this impossible climb. Just a really, really tough spot to be in for everybody. And that's exactly why the Philippine legal system came up with something different. The whole idea is simple, really. Resolving a legal case shouldn't mean tearing a family apart. It's all about finding a path that's, faster, a bit simpler, and just more humane. All right, so here's our game plan. We'll look at what this path to resolution is, what you can actually discuss, the step-by-step journey, the role of the mediator, and finally, how you get to the finish line. Okay, let's jump right into our first section. We're calling this a different path to resolution. So, what does that actually mean? Let's get into the specifics of court-annexed family mediation. So the first thing to get is that this isn't just some informal sit-down. Nope, this is a formal process and it's actually mandated by the Supreme Court of the Philippines. The whole goal is right there in the Constitution, to make our justice system simpler, faster, and way more accessible for everyone. It's basically a confidential, guided conversation to make that happen. Right, so that brings up a really important question. What can you actually talk about in mediation? What's on the table? This is a huge deal because not every family issue is going to qualify for this process. And the law is super clear about this. You've got two columns here. On one side, you have the things you can mediate, stuff like financial support, custody arrangements, how to handle property, basically areas where you can find some middle ground. But on the other side, there are things that are completely off limits. We're talking about serious criminal matters, like violence, or fundamental legal questions like the validity of a marriage. That stuff has to go before a judge. The system is set up that way to protect people and make sure the big legal questions are handled by the court. Okay, now we're getting to the heart of it. How does this whole thing actually work? Let's walk through the mediation journey step by step. I think once you see the roadmap, it all feels a lot less intimidating. So it all kicks off with an official order from the court. From there, you'll either choose a mediator or one will be assigned. Step 3 is the first meeting. Everyone's together and the mediator lays out the ground rules. Now, step 4 is really interesting. They're called private caucuses. This is where the mediator can meet with each of you separately one-on-one. It's a chance to get to the real, private concerns that might be hard to say in front of the other person. And that's often where the breakthroughs happen. Finally, you come back together for a final conference to see if you can nail down an agreement. It's a really structured, thoughtful process. Okay, I have to stop here for a second because this next point is absolutely crucial. It's the foundation of the entire thing. All mediation proceedings are strictly confidential. And that's not just a suggestion, it's a hard and fast rule. It's what creates the safe space for people to actually talk honestly, which, let's face it, is the only way you're ever going to find a solution. So what does strictly confidential really mean? It means anything and everything said in that room stays in that room. Any admissions you make, any suggestions for a settlement, even the mediator's own notes, none of it can ever be used in any other proceeding. It can't be used against you if the case ends up back in court. This is huge because it means you can talk freely and explore all the options without worrying that your words are going to come back to haunt you. All right, let's talk about the person who guides this whole journey, the mediator. Their job is to make sure the process is fair and neutral for everyone. They're like the referee, but for conversation. And the number one rule for a mediator is impartiality. This means they are completely free from any favoritism or bias, not just in what they think, but in how they look, what they say, and what they do. Their job is to serve all parties, not just one. They're committed to the process, not to a person. And it's really important to know what a mediator does and what they absolutely do not do. They must stay impartial. They have to tell you about any conflicts of interest. But here's what they can't do. They can't give you legal advice, they can't force you into an agreement, and they definitely can't accept any gifts. Think of them as a facilitator, not a judge. They're there to help you talk, not to make decisions for you. And, this isn't just some casual gig. A mediator is actually an officer of the court. That means they have to follow the same high standards of diligence and fidelity as a judge. It's a serious role, and that official status really adds a layer of trust and integrity to the whole process.
Okay, so this brings us to the finish line. After all the talking and negotiating, what happens? What are the possible outcomes?
Well, it really boils down to two potential outcomes. Outcome number one, the ideal one, is a successful compromise agreement. And this isn't just a handshake deal. This document becomes the foundation for an official court judgment, which means it is 100% enforceable. But what if you can't agree? Then you get outcome number two, a certificate of failed mediation. And all that means is the case goes right back to the court to proceed as it normally would. No progress lost, no harm done.
And check this out for efficiency. Whether you succeed or not, the mediator only has 3 days. Just 3 days to get all the final paperwork, like that agreement or the certificate, filed with the court. So your case keeps moving, no matter what.
And that really gets to the heart of it all. The goal here is to give families a structured, humane way to solve problems. It's about empowering you to be the one who shapes your family's future, instead of leaving it all in the hands of a judge. So I'll leave you with this final thought. When it feels like talking is just impossible during a family conflict, remember this. The legal system itself has created a process that believes in the power of conversation. Not just any conversation, but a guided, confidential, and structured one. So the real question is, could a conversation like that change everything?